You are welcome to this presentation, which is a continuation of the presentations on defenses to criminal liability. This part is defenses to criminal liability, part 3. We want to begin to examine the excusatory defenses. If you remember, we said excusatory defenses occurs in a situation where the claimant is laboring under a disability which causes an existing condition and makes the claimant not to be, freely and voluntarily responsible for his actions in a manner as to be able to hold him accountable. So we'll begin today to look at defenses to criminal liability founded on excuse. The first one we'll look at today is the defense of intoxication, after which we'll look at other excusatory defenses. I will share my slides in a minute. Okay, so we are looking at defenses to criminal liability part 3, and the presentation is divided into 4 segments. There is introduction, there is involuntary intoxication, voluntary intoxication, and intoxication as a factor in negating the subjective mental element in crime. The learning objectives. At the end of the lesson, students should understand statutory provisions and judicial authorities governing the defense of intoxication. And for the learning outcome, we expect that at the end of the presentation, students should be able to explain and apply statutory provisions and judicial authorities governing the defense of intoxication. Now, meaning of intoxication. According to Black's Law Dictionary, intoxication refers to a diminished ability to act with full mental and physical capabilities because of alcohol or drug consumption. When a person consumes alcohol or drug, the effect of the alcohol or drug consumption may be to lead to a diminished ability. The person is no longer fully in control of his mental and physical capabilities. And because he is not fully in control of his mental and physical capabilities, the law may excuse him if in that state he commits an offense. Now, the general rule under Nigerian law is that intoxication is not a defense to criminal charge. That's the general rule, is that intoxication is not a defense to criminal charge. And you can see that general rule in sections 29(1) of the Criminal Code and section 52 of the Penal Code. Now, what is the rationale for this general rule? Now, if a person, knowing that the consumption of alcohol or drug can lead to a diminished ability to act with full mental and physical capabilities, and with that knowledge, it proceeds to consume alcohol or drug in such a manner as to produce a diminished ability to act with full mental and physical capabilities. And in that state, he now commits an offense. The law will hold him responsible because he was the one that initiated the process of his losing his mental and physical capabilities. The law will not allow a person to voluntarily and freely consume alcohol or drug, gets himself intoxicated, which may lead to diminished ability to act with full mental and physical capabilities, and then allow him to turn around if he commits an offense in that state to say that, I'm sorry, I wouldn't have committed the offense if I was not intoxicated. So that is a rationale for the general rule. Now, the law in Nigeria, however, draws a distinction between the effect of voluntary and involuntary intoxication. Now, these terms, voluntary and involuntary intoxication, are not used in the criminal or penal codes, and they are merely used to categorize the possible effect of intoxication in certain contexts. Involuntary intoxication. The law in Nigeria allows a defense where the intoxication was not with the consent of the defendant or the claimant, where the claimant did not, voluntarily, freely, knowingly intoxicate himself. So the law allows a defense where the intoxication was not with the consent of the defendant. If, for instance, a person's drink is spiked either with drugs or other intoxicants, and unknown to him, he consumes the drink, and then he now loses his full mental and physical capabilities to be able to control his action and commits an offense in that state. That is a case of involuntary intoxication, and the law will allow him to, the law will excuse him for whatever offense he has committed because he was involuntarily intoxicated. Section 29(2)A of the Criminal Code allows a defense of intoxication to a crime if the defendant did not know that such act or omission was wrong or did not know what he was doing by a state of intoxication caused without his consent by the malicious or negligent act of another person. So if another person maliciously or negligently spikes your drink or adds, a drug or other intoxicants into your drink, as a result of which you become involuntarily intoxicated, then the law allows you a defense for whatever crime that may be committed. Under Section 52 of the Penal Code, the law allows a defense of intoxication where something administered to the defendant without his knowledge or against his will make him incapable of knowing the nature of the act, or that is doing what is either wrong or contrary to law. Again, the intoxicant here causes a disability which makes the claimant or the defendant not to be a free and voluntary agent, and as such, for the law to make him accountable or responsible for whatever offense is committed. Now, these provisions do not cover the provisions under Section 29(2)A of the Criminal Code. The provisions under Section 52 of the Penal Code do not cover self-intoxication by mistake, or where the intoxicant was administered on the defendant accidentally. So it is possible for somebody to, by mistake, take a substance that may intoxicate him. In other words, he took the intoxicant mistakenly, or where the intoxicant was administered on the defendant accidentally. The intoxicant was not administered on the defendant maliciously or negligently, but accidentally. The provisions of Section 29(2)A of the Criminal Code and Section 52 of the Penal Code does not cover these grounds of involuntary intoxication, meaning that in those circumstances, a defendant will not be able to rely on the defense. And you will agree with me that that may be a little bit unfair because the defendant did not go about deliberately, intentionally to get himself intoxicated. He only did so mistakenly. Maybe he mistakenly took, overdose on a drug, thinking that he's supposed to take a particular dosage of a drug, and he mistakenly overdosed, or where the intoxicant was administered to him accidentally, by another. The law will not provide him with a defense, and this will appear to be unfair in the circumstances. Now, that error has been remedied, or that gap in the law has been remedied under the Criminal Law of Lagos State, 2011, by adding the phrase accidental act of another person, or by the defendant to himself mistakenly after the words malicious or negligent. So the effect of the amendment to the law in the Criminal Law of Lagos State 2011 is now that the provision now covers, accidental act, or where the defendant mistakenly, intoxicates himself. Intoxication is defined in Section 29(5) of the Criminal Code to include a state produced by narcotics or drugs. So a person who consumes narcotics or drugs, that is deemed to be an intoxicant. Voluntary intoxication. The provision of section 29(2)B of the Criminal Code provides a defense if the defendant was by reason of intoxication insane, temporarily or otherwise, at the time of the act or omission. Now, ordinarily, voluntary intoxication does not provide a ground for excuse. But section 29(B) of the Criminal Code provides a defense if the defendant was by reason of intoxication insane, temporarily or otherwise, at the time of the act of omission. Now, if the effect of the intoxication on the defendant is to make him come within the legal definition of insanity under the Criminal Code, the effect of the intoxication, maybe over a period of time, is to make him to suffer from a mental disease or natural mental infirmity to the extent that he has now lost any of the three capacities provided under the grounds of the defense of insanity. Then the criminal provision says that will allow him, to raise a defense. But really, there's nothing new in the provision of section 29(2)B, because section 29(2)B does not really create any new defense. Because once a defendant is within the legal definition of insanity, it does not matter what causes the insanity really. If is within the legal definition of insanity, the insanity is caused by mental disease or natural mental infirmity to such an extent as to lead to a loss of capacity to control his action, to know that he ought not to do the act or make the omission, and so on and so forth, then the defendant can rely on that. So really, the provision of section 29(2)B is really nothing new. It doesn't add anything to the provisions of the law. In R. and Owari, 1939, 5 Waka at page 66, the West African Court of Appeal approved a statement in the case of DBP and Baird, 1920 AC 479 at page 500, in which Lord Birkenhead stated that insanity, whether produced by drunkenness or otherwise, is a defense to the crime charge. So once the effect of an intoxication is to bring the offender within the legal definition of insanity, then the defendant can raise the defense of insanity. It doesn't need to raise any defense under voluntary intoxication. Section 29 of the Criminal of Lagos State 2011 did not replicate section 29(2)B of the Criminal Code, because like I said earlier, the provision does not add anything new to the law. There's no provision under the Penal Code like section 29(2)B of the Criminal Code. I agree with the view that unsoundness of mind under the law of insanity, under section 51 of the Penal Code, should be interpreted to include cases where the unsoundness of mind is brought about by voluntary intoxication. So if it is voluntary intoxication that has produced a mental disease or natural mental infirmity to such an extent as to make the defendant to lose any of the capacities defined by the law for the purpose of the defense of insanity, then the defendant can raise the defense of unsoundness of mind under section 51 of the Penal Code. So the Penal Code, not having a provision like section 29(2)B of the Criminal Code, I mean, nothing is really lost by that, by not making a specific provision to that effect. Now, there is also another scenario where intoxication may be a factor in negating the subjective mental element in crime. A situation in which intoxication may be a factor in negating the subjective mental element in a crime. Now, it is important for clarity to stress that the only instance where voluntary intoxication can constitute a substantive defense under Nigerian law is the provision of Section 29(2)(b) of the Criminal Code discussed above. There is, however, the provision of Section 29(4) of the Criminal Code, which provides as follows. Intoxication shall be taken into account for the purpose of determining whether the person charged had formed any intention, specific or otherwise, in the absence of which he will not be guilty of the offense. Now, the first point to note with respect to this provision is that it does not create a substantive defense to criminal liability. It does not. It only says that if it is an offense, if the offense charge is an offense that requires a subjective mental element, for instance, an offense that requires the mental element of intent, intoxication may be considered whether that intoxication negated the subjective mental element in the crime. In other words, whether the fact that the defendant got intoxicated did not made it impossible for him to form the mental element required to form the offense. To constitute the offense. And the example, that I usually give here is this. Imagine a situation in which two good friends went to a party, and there was a lot of alcohol, in abundance available at that party. And the two of them got completely drunk. Okay? There was no existing quarrel between them. There was no pre-existing conflict. So as they were about to leave the party, the two of them were about going home, completely drunk. They now saw a young lady, and the two of them began to make advances to the beautiful young lady. And in the course of their attempt to gain the attention of the lady, a quarrel suddenly just broke out between the two of them, and they started arguing. Don't you know that I was the first one to speak to her? Each one was claiming that I was the first person to speak to her, and a fight broke out. And in the course of the fight, bottles were broken, and one of them stabbed his friend, and his friend bled to death. Now, in this kind of a situation now, there is death. He has stabbed his friend with broken bottles. That is sufficient to constitute an intention to cause grievous bodily harm, which is one of the grounds for which a person can be convicted for the offense of murder. Okay? So, the prosecution needs to prove either that he intended to kill or he intended to cause grievous bodily harm. Now, at the state at which both of them were at the time the young lady came in, like I said, there was no evidence of any pre-existing quarrel between them. They were very good, jolly friends. They enjoyed the party. But they had so much to drink that they were completely drunk. So that kind of a situation can support the fact that despite the voluntary intoxication of the two of them, the circumstances was such that it negated the subjective mental element required for the particular offense. The subjective mental element required for the offense of murder there is either intention to kill or intention to cause grievous bodily harm. Now, because the two of them were completely drunk, it's difficult to say that the one that stabbed his friend to death had the intention to kill his friend or to inflict grievous bodily harm. Because the circumstances was such that, like I said earlier, there was no pre-existing quarrel between them. They had both gotten so completely drunk that they could not even form the mental intention. Neither could form the mental intention required in that circumstance, either the intent to kill or the intent to cause grievous bodily harm. So it is in this kind of a situation that voluntary intoxication can negate the mental element in a crime. And of course, you will remember, when we were in the previous lectures, when we studied the legal elements of an offense, it was stated that both the actus reus, the physical element, and the mental element of an offense must exist. So if, in this instance, the prosecution is not able to prove the subjective mental element in the offense of murder, which is either intent to kill or intent to cause grievous bodily harm, then the intoxication here has negated that subjective mental element. So what that then means is that the prosecution will not be able to successfully establish the mental element of the offense of murder, meaning that intoxication in this instance, even though it is voluntary, negated the subjective mental element. So what it would then mean is that the offender will not be liable for the offense of murder. But that is not the end of the matter, though, because death has resulted. The prosecution may actually consider, charging him for the lesser offense of manslaughter. In fact, the court can convict him of the lesser offense of manslaughter because he had used, violence that was an unlawful act by stabbing his colleague, his friend with broken bottles. That was a dangerous act. So all the elements of, manslaughter by recklessness, or by gross negligence can be established there. So he can actually be convicted of the lesser offense of manslaughter, but not of the offense that requires, a subjective mental element like the offense of murder. So it is in this kind of scenario that intoxication can be a factor in negating the subjective mental element in the crime. Okay, so I think I've taken sufficient time to explain that. In the English case of DPP and Bird, 1920 AC, page 479, at pages 501 to 502, Lord Buckingham stated that the evidence of drunkenness, which renders the accused incapable of forming the specific intent essential to constitute a crime, should be taken into consideration with the other facts proved in order to determine whether or not he had this intention. Now, if you apply this ratio to the scenario of the two friends who got drunk, you can see that the evidence of drunkenness there rendered the accused incapable of forming the specific intent essential to constitute the crime of murder. And then the court will also consider other facts. I mean, like I said, there was no evidence of any pre-existing quarrel or animosity between them. They were good, jolly friends. It just happened that, they got so drunk and they were no longer in control of their actions. And unfortunately, if a fight ensued and one of them got stabbed and died. Now, where intoxication is considered, and the court concludes that having regard to other circumstances of the case, the offender could not have formed a specific intent, then the offender will not be liable because the prosecution would not have proved intent. And where the prosecution failed to prove intent in a charge of murder or even in any other offense that requires specific intent, then the prosecution will not be able to sustain conviction for that offense. Now, the question of whether intoxication is enough to negative intent is a question of fact in all the circumstances of the case. The court will look at all the circumstances of the case. If available facts suggest that the defendant, despite his intoxicated state, had specific intention to kill, the court will convict him of murder. In other words, there could still be evidence to show that although the defendant was intoxicated, there are some other evidences that show that he had a specific intention to kill. And then the court will convict him of murder. And that was the case of R. and Oweri, 1939, 5 Waka, at page 66. The defendant had a quarrel with one of his fellow employees. And later, he now went out and got himself drunk. And the evidence was that he now picked up a gun and went looking for his co-employees. He went around looking for him. And when he found him, he shot him and killed him. What does that suggest? That suggests that the fact that he went about deliberately looking for him suggests that despite his voluntary intoxication, he had the intention to kill him. So what the intoxication did was just to give him Dutch courage, was just to give him enough boldness to be able to carry out his unlawful conduct. So the court rejected the plea of intoxication in that instance, and he was convicted of murder. Section 29(4) applies to all offenses involving any intention, whether specific or otherwise. Now, under the common law, offenses of specific intent are offenses involving purpose or conscious desire by the offender. Under the common law, if you say an offense is an offense of specific intent, then it involves purpose or conscious desire by the offender. General intent or basic intent denotes the remaining types of fault that a crime might require, such as knowledge, recklessness, or negligence. Therefore, Section 29(4) applies to all offenses involving intent, either as specific, general, basic, direct, or indirect intent, depending on the wording of the mental element in the criminal code. So we have looked at the defense of intoxication, and we started by explaining the meaning of intoxication, and we said at the beginning that it referred to a diminished ability to act with full mental and physical capabilities because of alcohol or drug consumption. We explained the rationale for the rule, and then we went on to look at involuntary intoxication, to look at voluntary intoxication, and then to look at the situation in which intoxication may be a factor in negating the subjective mental element in the crime. So take time to listen to this lecture and come prepared with your questions, requests for clarifications, or in any area of the lecture that you want additional information. Listen to it and be prepared so that we can have a very engaging time when we meet in class. Thank you very much. And so don't forget to press the subscription button so that as I post additional presentations on defenses to criminal liability, you'll be able to get it immediately. Thank you very much, and God bless.